Hello, Nandini Narayan here from Congressman Khanna's office. This is Liz. Hi, Nandini Narayan here from Congressman Khanna's office.
And Bert Merkel is here as well.
Hi, it's Marty Paoni with Prime Policy.
And Rich Mead with Prime Policy Group as well.
Here's the solution to things to think about.
Hi, for the people on the teleconference, we have not started the meeting yet.
Thank you.
Good morning, all. This is the County of Santa Clara's Federal Affairs Advocacy Task Force, and the hour of 9:30 having arrived, we're going to ask the clerk to call the roll. Establish a quorum. Here.
Here.
We have a quorum. Thank you. First item of business is public comment, and we have one card under public comment, and that's for Mr. Scott Largent. Mr. Largent, you want to come on up?
Oh, great. Thank you. All right. Good morning, everyone. Good morning, Supervisor Cortese, Joe Simidian. Today at criminal court, we have another appearance for Victorious Alexander. He has now, I believe it's 9 charges for trying to use our reentry facility that's at the corner edge of this property. It used to be San Jose's Communication Center. For him going to court today, he's violating the stay-away order that's in place for Supervisor Cortese and also Cindy Chavez, and you also, James Williams. So he's going to violate it again going to court. He's not able to utilize the reentry center over there. He's going to try to go pro per today because he doesn't want to use the shady attorney that's been assigned through the IDO. That is part of the hustle, part of the scam of kind of throwing him under the bus. So he's not able to use the reentry center. He's not able to go to the public defender's office. He can't even go to the Department of Corrections and collect his $19 that he had when he was arrested. He can't go there. Why would his case not be moved to our new Family Justice Center? They do mental health cases there, family court cases, and they've been doing some criminal court cases there. It would have been convenient to have moved it over there so he could attend court. I mean, it just seems like a simple thing. there should have been exceptions for using the resources that he would need to use, being pro per or being released from our jail. And that doesn't seem to be happening. I think it's really cruel what you guys are doing to him. And I would ask you guys to, throw in the towel on the poor guy. It's just not okay. I understand there's existing restraining orders, and he'll have his day in civil court, but this is just absurd. He left from our jail, and he went over to use the reentry center. Now, the reentry center is barking back that he didn't sign up for services. I filmed it when I was in there. He inquired about services. He started the process of doing it. But isn't that his personal and confidential medical records right there also being released? And I'd like you to know this also, Supervisor Cortese, that in these restraining orders, all his personal and confidential medical records were put into those restraining orders. They were released from the state over there at our courthouse, and they were put into these restraining orders. That's his confidential information. It should have never been put in there. And several judges have mentioned this in court, that this stuff should not have been in there. So it's violating his HIPAA rights, his civil rights. I mean, give the guy a fair shake. I know you guys had some differences with him, but you too could make that happen. And Joe, you don't even have a restraining order against Victorious. He liked your leadership a lot. He didn't have a problem with you either, Dave. We respect what you're doing in here. I'm just worried the stuff and the information that was relayed to you from our sheriff's department about what we were doing coming in here was wrong. You guys were misled. Okay, and I am upset that he's having to go through this. So today's going to be another interesting one. He'll address the court. He's going to go pro per, and he's going to expose the scam. So thank you.
Thank you. That concludes public comment. I'm going to confirm that with the clerk that we have no additional cards, and we do not. And by the way, Supervisor Cortese, I know we're all struggling with some scheduling challenges this morning. I do want to mention, by the way, that Nandini Narayan from Congressmember Ro Khanna's office is participating by phone, and we welcome her and thank her and the congressman for their participation.
Thank you so much.
Thank you. And that takes us to item number 3, which is to approve the consent calendar and any changes to the task force's agenda. And we'll just ask for a motion by Supervisor Cortese to approve the consent calendar, which consists solely of the minutes. Supervisor?
Move the consent calendar.
Motion by Cortese, second by Simidian. Without objection, so ordered. Thank you. That gets us to our regular agenda, which is to receive verbal reports from the chair and the vice chair relating to items of interest to the task force. And I will just say I had a chance to participate in the Silicon Valley Leadership Group's delegation back to Washington, D.C. recently. It was, I thought, a good trip, hampered a little bit by the fact that there was a last-minute change in congressional schedules. So folks were asked, as I understand it, to fly in on Monday night from all around the country as members of Congress, and then with the final votes on Wednesday morning before folks went back home. And that hampered the trip a little bit, but we still had good visits. I did have a chance to visit with Congressman Khanna in his office, and we had a chance to catch up, talk about things of importance to our districts here in Santa Clara County. And last thing I will say, Supervisor Cortese, just it was a reminder of how differently the immigration issue is viewed by folks in other parts of the country. Just if we need an occasional reminder that the rest of the country doesn't always see things through the same lens that we do, certainly got it on that trip. Anything from you that you'd like to share this morning? Just
yeah, quickly, just let me indicate about, I think it was probably about a week after you were in Washington, D.C., I was there with the Metropolitan Transportation Commission, a trip that is made out there annually to do the work of the region in terms of transportation funding. I thought the experience was rather bleak relative to several past such trips that I made back there, irrespective of the makeup of the Congress or the White House or anything else. There just was not a lot of positive ideas on the table in terms of how to get to where we need to go. That said, we did our best to to put forward the county's views and the region's views, in terms of infrastructure needs here primarily. I do also, under this item, just want to ask, openly ask Danielle and our team to get in touch with my office regarding some federal grant funding that's being held up relative to the HCP, which we're, of course, a big, significant member of, and that just came to our attention the last couple of days. Similar, it seems similar to some of what we've heard happening in the region, in the county, where appropriations have been made, and the only thing left is for an agreement to be signed and dollars to be turned over, and that's just not happening. So the reason to refer to you first and foremost, of course, is because there may be something from a lobbying standpoint that Prime or somebody could do back there to try to break through that. And again, my office has more details. Thank you.
Thank you, Supervisor. That takes us to item number 5, which is to receive the verbal report from the County Executive's Office relating to items of interest to the task force. Anything today, Mr. Marquez?
No, simply to say that apart from the politics of the day that seem to be consuming cable TV, the real big issue in Washington, D.C. right now is, of course, the budget, the federal budget. I understand the House and the Senate are in session today and tomorrow, then we'll be out for 2 weeks. But notwithstanding that, the omnibus appropriations bill was released yesterday at about 8:15 p.m., and the rule that will adopt its consideration was not released until 1 a.m. But I note just broadly, it has no DACA fix, and it does include an extra $10 billion currently for HHS. But item 8 is going to have a much more detailed report on that. But big picture, the only thing of substance going on really is that federal budget bill.
Thank you very much. And that takes us to item number 6, which is to receive a verbal report from the Office of the County Council relating to items of interest to the task force, including the interim rules on religious and moral exemptions and accommodations for coverage of certain preventive services under the Affordable Care Act, which is a mouthful, Mr. Williams. Let me just say that working with Supervisor Cortese's office on the administrative side, we determined that we'd like to spend some time today getting updated about issues of particular importance to women in the community, and so that'll be the focal point of many of the conversations that we have today on a wide range of topics. So, Mr. Williams, let me turn to you.
And if I may, President Simitian, just to indicate, I have to leave for a memorial service immediately after this report. I'm sorry to miss the rest of the agenda, but I wanted to be here for those items that needed both of us.
Thanks, and I know you've got staff monitoring as well.
Yes.
Thank you. Mr. Williams?
So I'll begin with just kind of a very brief overview, and then I'll talk specifically about these two rules that the Trump administration has put forward related to the Affordable Care Act. We've included in the packet, again, our monthly update of litigation involving Trump administration activities. We've continued to keep that updated. Obviously, the county is heavily involved in a number of those cases, including participating as amicus in many other cases. I did want to just note, for the benefit of everyone publicly, we have oral argument at the Ninth Circuit Court of Appeals in San Francisco in the morning of April 11th, so coming up in just a few weeks, on the appeal of our permanent injunction in the sanctuary jurisdiction executive order case. So that might be something of note and interest. There also are appeals pending in the DACA case. Obviously, that injunction in that case is currently basically the only thing providing some relief to those eligible recipients to be able to continue with their status since the March 5th original deadline that the Trump administration had basically put forward has now come and gone. So there are appeals in the Ninth Circuit pending related to that injunction as well, and a number of other cases. In terms of these two proposed rules, what the Trump administration has done is the rules kind of fit together hand in hand. The Trump administration issued these interim final rules and did so to do two things: to basically significantly expand the religious exemptions under the Affordable Care Act, and to create a new exemption for so-called moral concerns under the Affordable Care Act. And this is basically folks who don't want to provide the otherwise mandated coverage of comprehensive care for women on contraceptive, coverage, basically, and other preventative services. This was obviously something that was heavily litigated under the Affordable Care Act in the Obama administration. There were cases to the U.S. Supreme Court, and the U.S. Supreme Court in the Hobby Lobby case in a 5-4 decision determined that closely held corporations could invoke the Religious Freedom Restoration Act, which is a statutory protection under federal law, to basically opt out of providing coverage or participating in any way in the provision of coverage based on religious beliefs held by that closely held corporation, Hobby Lobby being, a large company, but one of those closely held corporations. That was a very significant expansion of the kind of entities that had historically been understood to be able to claim religious exemptions. I mean, at its core, looking back before this decision, really, the prior decisions were focused on entities that were pretty expressly religious in orientation. For example, churches and other religious organizations. And so the Supreme Court really expanded things quite significantly. These proposed rules under the Trump administration actually go even further than that. The first rule takes that religious exemption kind of articulated in the Hobby Lobby decision and expands it to large publicly traded companies so that they would be able to claim that on the basis of their religious beliefs that they should be exempted. So in essence, anybody. And then the second rule takes it even a step further to say, even if you don't actually have any religious belief that you're asserting, if you just have a moral objection, even if it's not grounded in any religious belief, that you should be able to claim an exemption. And it also allows these exemptions to apply to health insurers themselves, which is particularly concerning in terms of the provision of services, because the kind of workaround, so to speak, that was happening in the Obama administration was to allow the business entities or the religious organizations to decline to participate, but impose the requirement nonetheless on the health insurance company to continue to provide access to such services. So this would actually allow those health insurance companies themselves to claim the exemption. So in essence, it would allow anybody who wanted to opt out to basically opt out of providing these core preventative services under the Affordable Care Act. Now, the interim final rules were issued without notice and comment as kind of invoking emergency rulemaking. As a result of not following kind of the regular process for rulemaking, injunctions were issued. There were cases filed, litigation was filed, injunctions were issued in 2 separate cases blocking the interim final rules, so they have not gone into effect. That being said, the notice and comment has been held on the rules. The county actually did submit comments on December 5th on these rules, and we're now awaiting kind of final publication of the rules through the formal notice and comment process, which will probably then, after that's done, lead to a subsequent round of litigation. So that's kind of what's going on with that, but it's essentially an effort by the Trump administration to eviscerate those protections under the Affordable Care Act.
And Mr. Williams, let me just ask a couple of questions, just dig into the weeds a little bit here so I understand more fully. Who is it that actually promulgates the rules? I mean, we speak broadly, obviously, of the federal government promulgating the rules, but is there a particular department or agency that we're working with here?
So these rules have been published by the Department of the Treasury, the Department of Labor, and the Department of Health and Human Services.
And do they each take a piece, or do they all jointly issue the three bodies issue the same thing? And if these are questions for which there are answers on another day, that's fine. I'm just trying to understand the process a little bit.
I believe these have been jointly issued by the departments.
All right. And could you clarify again for me, please, the process where there was we've got essentially 2 rounds of issuance, and just walk me through that again, if you would, please.
Well, so what they did is they invoked a process where they put forward the rules for immediate implementation and then do notice and comment. So the normal rulemaking process is you publish a proposed rule, you go through notice and comment, then you publish a final rule, and only after that publication does the rule go into effect. What they did here was they published an interim final rule that took effect immediately, and then proceeded with notice and comment, which could lead to a revised rule. That process is supposed to only be invoked when there are exceptional circumstances that require rulemaking without any delay in implementation. And that effective date basically has been stayed, in essence, by the injunctions that have been issued in court saying, no, these shouldn't have been issued as interim final rules. They should have been done through the normal process.
And excuse me, just so I understand, and the argument presumably was that there were not exceptional circumstances justifying that particular process?
That's right.
Thank you.
And like I said, two different district courts on, one in Massachusetts and one here in California, both granted preliminary injunctions. Actually, sorry, one in Pennsylvania and one in California.
And then that means that we're in a second round of commenting opportunities, or no?
No, it's the same. So even when you issue an interim final rule, you do kind of an after-the-fact notice and comment, and so that is the process that is now playing out.
So the timeline looking ahead now is what again?
So we've submitted comments, and what is now basically the ball is back in the department's court to promulgate final rules based on the notice and comment that's been received. They'll have to respond to the comments in whatever they put forward.
And not to second guess too much, but I don't think we have any reason to believe that the final rules will look much different than the rules we've already seen.
I would venture that that's unlikely.
Okay. And then when the final rules come, there's the potential for litigation, depending on the content of the rules, obviously, and the response from our county and others around the country, yes?
Yes. So, we'll have to see how adequately they respond to comments. They have a duty to respond to substantive comments in the process. We'll have to see exactly what the rules themselves say. And I think, the biggest issue with these rules is when you look at them together, they, for practical purposes, allow anybody to opt out of this mandatory coverage under the Affordable Care Act, which is contrary to the statutory scheme.
So the level, the nature and level, I guess, not so much the nature, but the level or extent of potential harm is to some degree unknown, because we don't know if and when the final rules were to take effect, what number of corporate entities would take advantage of the opportunity to exercise the exemption. Is that the uncertainty that we're facing?
Yes, that's definitely one element of uncertainty. What kinds of entities will large publicly traded companies avail themselves of this new ability to claim an exemption? I think that that's very much an open question. Some states like California, the effect is also a little harder to figure out because there's independent state laws that may trigger some or all or many pieces of coverage anyway, regardless of what's required under the Affordable Care Act. So that may help in terms of folks who live in the state of California. But this is obviously a national issue of concern. So we'll see. But I think there's little question that there will be more entities claiming exemption, meaning, as a practical matter, more women who will not have access to coverage for these critical services. Where exactly they'll be, how many is not known, but there's little question that there'll be more women denied coverage.
All right. Thank you. Anything else to report on this item?
No, I think that concludes my report.
Thank you. Then before we leave this item, even though this is a verbal report from the Office of the County Council is agendized as item number 6. Let me just ask, because we have some folks both here in the chambers with us and also on the phone, Ms. Christian, and I should have introduced Pratima Pandey earlier, forgive me, from here in the county. Any comments or thoughts on this particular item, the interim rules and or the potential for final rules regarding religious and moral exemptions?
Thank you, Supervisor. I just want to comment that later on when Ms. Christian will talk about VOCA funds, I do intend to address the piece that County Council talked about, the religious and moral exemptions, because nationally VAWA is getting ready to be reauthorized this year, and as part of the reauthorization efforts, there is a concern that there could be moral and religious exemptions added to the reauthorization piece. VAWA currently is the only law that actually uses specific words that say that prohibit discrimination on the grounds of gender identity, sexual orientation, and nationally the task forces that are working and keeping an eye on the reauthorization bill are worried that moral exemptions and religious exemptions will be inserted at that place, and I will be addressing the task force on that more.
Thank you. Let me go to folks who are joining us by telephone. And again, we're on the issue at the moment of the moral and religious exemptions debate around interim final rules initially, and then ultimately the potential for final rules. I know we have folks with us today from Prime Policy, our legislative advocates, as well as Mr. Margolin, I believe. Would either care to weigh in on this issue or give us anything else in the way of insights that would be helpful?
This is Rich Mead from Prime Policy Group, and I just add one other bit of context, and this might be somewhat unrelated to this issue, but nevertheless, I think it's very telling. Because the court actions in cases against this interim final rule, that has actually given great pause to all the other agencies throughout the federal government in terms of their rulemaking, in terms of this notion of not sort of reaching too far in regulatory efforts. So this impact in this case is having impact on many other issues sort of across the board throughout this administration, which I think is fairly significant.
Thank you. So to those who would argue that the exceptional circumstances did not exist justifying the rulemaking in this case, I gather what you're saying is that the fact that the courts agreed with that has had an impact beyond this specific issue, yes?
Yes, that's correct.
Got it. Thank you. And Mr. Margolin, if you're with us, anything else you want to share on this item before we move on to item 7?
Yes, well, I will be talking about item 7 in a moment. And the one point I would make is that when we talk about the statutory conscience rights that apply to healthcare workers and what's being done in that area, it's part of the same general effort that's being done under the Affordable Care Act, the effort to elevate these objections in a way that have the potential to interfere with access to health care. So we'll talk about that more in a moment, but it's all part of a larger theme.
Thanks. It's helpful to have that context. All right. Thank you very much. Then we're going to move on to, after saying thanks to County Council and the County Executive's Office, we're going to move on to item number 7, which is to receive verbal reports from the administration, and including our various consulting teams and other agencies here in the county regarding federal policies and rules and legislation, specifically regarding issues of importance to women in the community. And let me just ask all participants, because I know some are new to the conversation today, if there's an acronym to be used, could people please articulate what the acronym stands for, just in the interests of growing all of our knowledge on some of these items. So we've got items 7A, B, C, and D dealing with specific issues. Ms. Christian, may I look to you to walk us through this conversation?
Yes, thank you. I'm going to provide just a quick comment about Title 10, and then I'm going to ask Burt Margolin to provide more information on this item as well as on item B following his Title 10 comments. Title 10 is the Family Planning Grant Program. It's a $286 million federal program that is dedicated solely to providing individuals with comprehensive family planning and related preventative health services. It is legally designed to prioritize the needs to low-income families or uninsured people, including those who are not eligible for Medicaid, who might not otherwise have access to these health care services. The services are generally provided at reduced or no cost. On February 23rd, the Trump administration released its funding opportunity announcement, commonly referred to as an FOA, for Title X Family Planning Service grants. Applications are due in May, and grants will be rolled out in September. And I'd like to ask Burt Margolin to talk a little bit about what that funding opportunity announcement contained and some of the concerns that exist within it.
Thank you. Yeah, happy to address the Title X issue. As was indicated, this is a very, very important, long-standing family planning program. It serves over 4 million individuals nationally, 1 million of whom are in California. We have 25% in California of the national patient population. There have been battles in the Congress over funding for this Title X family planning program, and in recent years, the typical pattern has been that the House has either zeroed out the Title X funding or reduced it significantly. The Senate has resisted, and in the end, Title X funding has been maintained. The Trump administration this year, in the funding opportunity announcement that Ms. Christian just referenced, is taking a different tack. Rather than going after the funding and saying that we're going to zero it out or substantially reduce it, they, in fact, are saying in this FOA that they're going to repurpose it. They're going to redirect how the dollars actually are spent. Existing Title X, and this is historically how the program has operated, has been evidence-based. It funded programs that provided contraception services that were providing scientifically validated birth control methods and opportunities. The new funding opportunity that we're dealing with, the one that was just released, omits the evidence-based standard and significantly broadens the universe of organizations that could win these dollars. And a key theme here is a new emphasis on what's referred to as fertility awareness methods, often referred to as the Rhythm method. This new proposal explicitly promotes single method sites as well. In the past, they've wanted Title X providers to offer a range of modalities, a range of treatments. This single method emphasis could allow abstinence-only providers to win these dollars, not something that could happen under the current structure. Again, abstinence is part of counseling about abstinence and deferring sexual activity is certainly part of what Title X providers currently do, but it's a relatively small part of what they do because, again, evidence-based, scientifically based strategies lead them to provide contraception medications and other services that are found to be more effective in reducing unwanted pregnancies. Beyond what I've just referenced involving the single method site, the FOA also urges providers to communicate, explicitly urges them to promote and communicate an abstinence-only message to adolescents. So, in general, what we're dealing with here is an FOA which downgrades by actually eliminating reference to evidence-based methods. It upgrades the Rhythm method, fertility awareness is upgraded, and it gives abstinence a new priority as a key message for Title X providers. And then the last thing that this FOA does that's worth noting is it changes the way the decisions are made about where the dollars go. It not only has created new criteria, which we've just gone over, which is going to fundamentally shift potentially who gets these dollars, but it also gives a single senior Trump administration official the unilateral authority to distribute the dollars. Currently, it's a collaborative process. It's been this way for about 30 years, where you have a regional HHS official making a recommendation based upon applications in that region. Then that goes to senior management in the Health and Human Services Department in Washington, and through a collaborative committee process, they make decisions based upon the criteria that have historically existed. Now with this new, much broader criteria, which takes out the evidence-based standard, the person making that decision will be Valerie Huber, the acting Deputy Secretary for Population Affairs, and Ms. Hooper is not exactly a neutral figure when it comes to having opinions about how these dollars should be spent. Before she went into the Trump administration, she was the president of an organization called ASCEND, a national organization that promoted sexual risk avoidance, which is another term for abstinence, as its primary mission. So she's an abstinence advocate. She'll be deciding unilaterally where these dollars go. It certainly portends significant changes in the way the Title X program operates. Happy to respond to questions, or I can go on to the conscience rule, whatever you'd like.
Thank you. Just a few brief questions, and if we're going to be old school here in present, which is that if staff wants to comment or weigh in, I'll just ask you to raise your hand slightly so I can recognize you. And then for those of you who are on the phone and who I can't see, just pop right in and we'll try and negotiate the flow of conversation as best we can. Let me just ask Mr. Margolin before we go on. So just to be clear, the fertility awareness and rhythm methods that you speak of are also sometimes referred to as natural family planning. Is that another term of art that we're hearing for?
Yes, that's
all right.
Correct.
Just so we've got clarity about sort of the different terms of art people are using. And then, so this is a, where are we in this process? So FOA, which you mentioned, I believe, is a funding opportunity announcement, yes?
Yes, yes.
So where are we in this process? So this is happening, has happened, is about to happen, forgive me.
It is happening now with the goal of funding decisions being made over the spring-summer period, and the funding going into effect next September. So normally the funding cycle ended in March for the current grantees, and there is this gap period that the administration is going to have to deal with in some fashion, and I'm not exactly clear on what they haven't made clear enough as to what their strategy is going to be. They've talked about potentially allowing people to get some extended funding, and I'm sure in many cases there'll be a gap in funding, and funding will run out. But we're in the middle of organizations responding to the announcement and developing their applications.
And the ability to reshape, restructure these criteria rests in who again?
Valerie Hooper, the acting Deputy Secretary for Population Affairs. She's under this new structure. She's the single decision maker in Washington, the person running this program, the Title X program.
And let me ask you, and/or Mr. Williams, and/or anyone else in the conversation, is there any argument or debate about her authority in that role, or is that fairly well established and accepted, notwithstanding whatever policy differences people may have?
I'm not aware of a debate about her
Okay.
authority. Others may know more, but I'm not aware of one.
So it is what it is, and she is who she is, and that's the direction we're headed, as far as we can tell. All right.
Or we can tell.
And is there a comment process or anything like it that is part of this exercise?
No, because we're not dealing with the rule. We're dealing with a rule definitely has a comment period, but this is actually a funding announcement for an existing program, and they just administratively changed their criteria and structure, but they're doing it arguably within the law. I mean, there's always the potential, I would guess, perhaps at some point, based in part on what decisions they make, I could see litigation at some point if they take this in a completely indefensible direction. I mean, Ms. Hooper's indicated that existing providers are certainly going to be considered fully, and you're going to have providers who also are abortion providers, Planned Parenthood providers who've been a major part of Title X. She's in a sense sane or certainly eligible to be considered for this funding, but the proof will be in who actually gets the money. And I could see if there's some sort of discriminatory pattern or some pattern that suggests this wasn't a process consistent with the law and done fairly, that there could be some objection raised later legally. But right now people are operating as if these are the rules and we have to comply and put in the application and hope that existing providers are given fair consideration.
Understood. Given your reference to existing providers, am I correct in my understanding that Planned Parenthood is the one existing provider here in Santa Clara County? And I see Ms. Christian leaning in on this point.
Yes, I reviewed the January 2018 directory of grantees that was released by the Office of Population Affairs, and Planned Parenthood Marmonte is the only organization listed in Santa Clara County as receiving Title X funds.
And Ms. Christian and or Mr. Margolin and or anybody else, is it the norm that in, I mean, we're a good-sized county. I think we're in the top 15 or 20 size counties in the country. So is it the norm that there typically is only one provider who might be selected or identified for funding of this sort?
I'll comment on what I observed in the directory, and then
Please.
Perhaps Mr. Margolin can provide more. Just looking in the state of California, there were a few other areas throughout California that had other providers besides Planned Parenthood. For example, some parts of the state have public health departments that receive some funds. There were some other, what I would presume are community-based organizations or other nonprofit groups that received some funds. So I think at a quick scan, Planned Parenthood seemed to be the organization that was sprinkled throughout the whole state, but there were a few others in California. Mr. Margolin, do you have more to add to that?
The only thing I would add, it is true Planned Parenthood is a major Title X provider, but they provide care to a minority nationally of the Title X population. The majority of the money goes to providers other than Planned Parenthood.
Could you just give me, and understanding that I am not going to know the name of a large or well-regarded nonprofit in, Cook County, Illinois, for example, but just, I mean, who are these other providers? I'm just trying to get a rough sense for who else is doing this work that is potentially going to be affected in the way we might be affected here in Santa Clara County.
Again, I don't. It could be a community health center in some part of the country. It could be a public health department that chooses to do the work in an area where they don't have nonprofit providers able to do the work. It could be a community hospital that wants to seek the funding. Again, I don't have names available.
No, and that wasn't what I was looking for. Thank you,
Right,
Mr.
Right, but those are categories.
Thank you. So to frame it another way, Mr. Margolin and Ms. Christian, I gather whoever is doing the heavy lifting on family planning in a particular area is likely to be the organization that has sought and previously received these Title X funds. Is that a fair restatement, Mr. Margolin?
Yes, that's correct.
Thanks, and I appreciate staff's willingness to help educate me on this subject. So, all right. At this point, Mr. Margolin or Ms. Christian or others, is there, quote, anything to be done other than waiting, since simply waiting for what I think I would characterize as bad news is, not the ideal, but if that's where we are, that's where we are. But is there, absent the comment process, Mr. Margolin, what are people looking at in the way of action, if anything, at the federal level?
Well, I think the main focus really on the part of the Title X providers is to get their applications in and to look at the new criteria and do their best to meet it and hope that the administration, in fact, respects people who have a history in this realm and some level of expertise. It's clear, given who Ms. Hooper is and what her preferences are, that there'll be a reduction of funding for traditional providers. There'll be new providers included, providers who are involved in, for whom family planning is maybe a small part of what they do and not a major focus, and providers who do nothing but family planning, but who define it as only abstinent. So there'll be a new universe of providers, and there will be damage to existing Title X grantees, and the main focus right now is really for those Title X grantees, existing ones, to do their best to fight for a smaller piece of the pie.
Thank you. All right, Ms. Christian, back to you to help walk us through this item.
Thank you. Just a few brief comments, and then again, I'll ask Mr. Margolin to provide deeper information. A proposed rule protecting statutory conscious rights in healthcare was released on January 26th by the Department of Health and Human Services. And It would allow individuals and entities to use their beliefs to block patients from receiving the care that they need. And that's my brief introduction. Mr. Margolin, if you could take it from there.
Sure. So healthcare workers have long had the right, a limited right, to not participate in procedures they have a moral objection to. The issue has always been, and it sort of ebbed and flowed over the years based upon which administration was in power, is how broad is this right and how is it enforced? President Trump has created a new conscience and religious freedom division within the Office of Civil Rights, and he's given this new office broad authority to apply this conscience rule and broad authority to define it as well, potentially. At the same time they created this new office, they also proposed a new rule which would allow individuals to refuse to provide any part of a health service program. This is a very broad definition, and it essentially says if you assist in the performance of a named activity and you have a moral or religious objection to this activity, which you're assisting in, you can potentially excuse yourself from that activity. A very broad approach in this proposed rule that accompanied the creation of this new office.
Mr. Margolin, excuse the interruption, and I really do. I think you know by now. I really do want you to push back if I'm over extending it with the nature of your comment. But I mean,
sure.
Let's suppose somebody works in the back office of a hospital and has a moral or religious objection, conscience concern about providing abortion. If they work in the back office and they're part of the accounting and collections team, could they say, I don't want to be involved in collecting the payment from an insurer for a service that was provided? Or am I really getting, so far beyond the pale that that's an unlikely assertion? Or does it, and again, permission to speak freely, as we say in this committee.
Sure. I'm happy to speak freely. So, unfortunately, in this case, you're potentially correct. It is defined very broadly, and in the literature on this proposed rule, examples that are given of where opponents think it could apply, and it relates to your examples, are to receptionists who schedule abortion procedures, hospital room schedulers who schedule the actual procedure in the internal workings of the hospital, people who have administrative functions who are not traditionally viewed as the providers of the service. They could say, because this is an abortion service, or, and I'll get to the broader definition that could be troubling here, because it involves the same-sex couple, or because it involves a transgender procedure, something I object to morally, they might say, I don't want to schedule them. I don't want to talk to them when they come in to the front office. I don't want to. And in your example, it could apply to people who don't want to do the billings potentially. It could apply to almost any member of the workforce. They use terms like counseling, referral, training. It's very broadly defined.
Okay, then.
If I could go on with the referral language, many find especially troubling because it could interfere with the ability to send individuals to a place where they could get the care they need. If you're able to say, well, I object to this procedure, you're coming in seeking an abortion or some other procedure I have a moral concern about, not only am I going to not allow you to enter our facility and give you proper information, but I'm not going to tell you where you can go. I'm going to be silent on that, even though I know that there's a provider down the block that can do what you need to have done. I'm not going to give you that information. The other part of this that's fairly pernicious and troubling is the proposed rule does not even require the individual who's exercising their moral or religious exemption to tell the patient that it's being exercised. So they could behave in a manner that is secretive and withholding and potentially indirect, in effect misleading, and the individual, the patient, prospective patient who wants the procedure this person objects to, wouldn't even know that they're in that process. There already are conscious provisions for abortion and sterilization services, but again, this goes far beyond that potentially, and beyond interfering with access to abortions. Other examples that are given here are ambulance drivers potentially. Are they going to want to exercise this provision in the context of providing the care they provide? There's also, and this is why ambulance drivers are cited, there's no acknowledgement in the proposed rule that a duty to care is required in a life-threatening emergency, which typically you would do if you were concerned about ensuring that the rights of all parties were being respected. And again, while it's purely aimed at abortion services, this is sort of a main theme here, it also could lead to discrimination against lesbians, gays, transgender patients, a broad array of patients who an individual in a healthcare facility may object to on any range of moral grounds or religious grounds. And again, in a process where there's no disclosure and where the life and the health of the patient is not adequately acknowledged. So this rule, should it be implemented, will clearly be a problem in any region of the country where people seek care. In urban areas, probably less of an issue where people have other choices, but it's going to be especially troublesome in rural or underserved areas where the ability to deny care could very seriously jeopardize health, where you have limited choices, and if someone says, I'm not going to help you because you want care, you're a same-sex couple and you're coming in, and I object to treating same-sex couples under this structure, those kinds of scenarios could play out where people's health and safety is jeopardized. So again, it's similar to what County Council previously talked about in terms of the attack on the ACA implementation. It's an effort, and we can see that it's a multi-tiered effort to allow this concept of religious freedom and conscience to be as broadly applied as the imagination will allow. And of course, people will push back, and there's likely to be litigation down the road, and some of this may be limited down the road. But right now, the Trump administration is reaching very broadly and moving very strongly in this direction.
Thank you. And I'm going to look to Pratima Pandey to weigh in on this from our Office of Women's Policy.
Thank you, Supervisor. Just 3 quick comments. The populations that we did not hear about right now that I want to specifically highlight: teen parents, overwhelmingly mothers who are overwhelmingly living below the poverty line will definitely be impacted by this rule, because we do know that there is already discrimination that they face in accessing education as well as health care. The second population that I would like this task force to have its eye on is the undocumented families, both mixed status families as well as undocumented families who will seek services from Title X providers. Undocumented families are overwhelmingly living below the poverty line, and they do access health care through community clinics that get Title X funding, that may have workers who could now exercise this particular right to deny them services and or information and referral. And the third thing, and I don't know how this is related, but I just wanted to bring it up, I had a San Jose Mercury News reporter call me a couple of weeks ago asking if I knew that certain internet service providers, when you look for abortion service providers, those specific that specific term, abortion service providers, the results that show up first show all kinds of agencies that actually provide pregnancy-related services. So, going back to what was being talked about earlier in terms of abstinence and natural family planning related advice, I mean, that's what's showing up in particular search engines when folks are looking for abortion service providers. Just wanted to throw that in front of the task force. Thank you.
Thank you. On this issue of statutory conscience rights in healthcare, because this is a rule, Mr. Margolin, that means there is an opportunity for comment. Yes?
Yes.
And let me turn to County Council. My recollection is that County Council is or will be or has been preparing comments on our behalf. Am I remembering this correctly?
Yes, we will be submitting comments before the deadline.
And are those comments that we could ask you to share off agenda with board members as well?
Absolutely.
Thank you. Appreciate that. And then where do we go with that rulemaking process, Mr. Williams, if you are prepared to sort of take us down that path? So what's the process and the timeline look like here?
After the notice comment period concludes, the agency will have to respond to the comments and then decide how they want to promulgate their kind of final rule. And once we see what that looks like, we can assess kind of next steps.
All right. Anyone else on the call who'd like to weigh in on this issue, the proposed rule protecting statutory conscience rights in healthcare? All right. If not, then Ms. Christian and Ms. Bendy, you can lead us to item 7C, which is the rescission of the prior administration's guidance under Title IX on how colleges, universities, and K-12 schools handle sexual assaults.
Thank you, Supervisor. So existing law known as Title IX prohibits a person on the basis of sex from being excluded for participation in or being denied the benefits of or being subject to discrimination at any education program or activity that's receiving federal financial assistance. Title IX, along with the Clery Act, provides a landscape that requires campuses across the country to ensure that everyone can participate free from discrimination or gender-based violence, to ensure safe and equitable access to campuses and education nationwide. Title 10 I didn't do that, I promise.
No, you didn't. Good.
Title 10 implementation policies have broadly been issued as part of the Code of Federal Regulations, and in 2011 and 2014, the Obama administration specifically issued Dear Colleague letters, which contained the federal policy that allowed a framework of guidelines for campuses nationwide that they would follow when investigating cases of campus sexual assault. Some of the salient features of the Dear Colleague letters were basically relating to the to link campus sexual assault investigations to trauma-informed and victim-centered advocacy practices. What that did, three big pieces that I wanted to highlight for the task force. One was it clarified that the standard of proof required for investigation of campus sexual assault cases was preponderance of evidence. And the Dear Colleague letter of 2011 specifically referenced Supreme Court case law where Title VII, which is the prohibition of sex-based discrimination, Title VII clarified that the standard of proof required for Title VII violations was preponderance of evidence. The Dear Colleague letter also clarified that the Office of Civil Rights investigation procedure was considered an administrative investigation. Therefore, again, the standard of proof required. I promise you there's a reason I'm spending some time on this.
And let me just interrupt and say, I'm fascinated, so don't feel like you have to shortcut any of this. Seriously.
So the standard of proof, again, for administrative hearings was preponderance of evidence in the title. The Dear Colleague letter of 2011 clarified that preponderance of evidence standard is therefore what campuses should use when investigating complaints of campus sexual assault. The second thing that the
And excuse the interruption, just to be clear, the preponderance of evidence standard, is that the standard in order to commence an investigation or to conclude an investigation with a finding?
To investigate and issue a finding, the administrative body must use a preponderance of evidence standard, which is more likely than not something that was complained of happened.
But initially there is less than a preponderance of evidence. You investigate nonetheless, And then the question in making your determination is whether or not there is a preponderance of evidence. Yes? I've got a bevy of lawyers
Looking
here
at the
tonight
big
to look
lawyers.
to, so I'm looking at our bevy. Okay, they're all nodding. I think I'm on the right track. Thank you.
You're welcome. Thank you. The second thing that I wanted to point out that the Dear Colleague letter did was to clarify that the timeline for investigation was supposed to be 60 days, and this was based off of examining Office of Civil Rights complaints and the average time it took for OCR, which is Office of Civil Rights. Now I'll switch to the abbreviation. So OCR took an average of 60 days to complete an investigation, and so the Dear Colleague letter said that most campus sexual assault investigation complaints should be concluded within 60 days. However, the goal is to ensure that prompt and equitable action was taken the moment a complaint was filed. What that did was to ensure that the complainant as well as the respondent are not hampered in their ability to attend the educational institution while the investigation is pending. And the third, related to the timeline, the third thing that the Dear Colleague letter clarified was the ability of the investigating authority on campus to institute interim measures, which were measures that allowed for safety and protection of the complainant, and if the respondent needed, the respondent was able to ask for as well. But the focus was on, again, making sure that Title IX is upheld when Title IX, when a complaint is made, the complainant shouldn't fear that because he or she, an overwhelming majority are she, when they complain and they file a complaint for campus sexual assault, they shouldn't fear their ability to carry on their educational activities. And, to digress just for a minute, the last campus sexual assault case that I handled in my previous job, the 60-day window was a difference between my client being able to graduate from the institution here in California and not graduate. And for her, that timeline was critical for the investigation to be completed so that whatever the outcome was issued before her graduation date. And so the 60 days really makes a difference. We're talking about the future of our country. On September 7th, 2017, Secretary of Education Betsy DeVos issued a recession policy and specifically stated that the Dear Colleague letters of 2011 and 2014 would not apply as policy for campuses that receive federal funding. She went on to specifically issue Q&As. So both the 2011 and 2014 letters had Q&As that provided guidance against sort of roadmap for campuses who were investigating campus sexual assault cases. And not only were the letters rescinded, along with that, the Q&As that were attached to the Dear Colleague letters were also rescinded, in the sense that all the policies that formed the guidelines for campuses nationwide were all rescinded. Some of the salient problematic, if I may, supervisors, problematic items that were contained in the new Q&A that is currently the law of the land as far as policies for Title IX go. One is there is no longer a requirement for interim measures that are victim-centered. In fact, the Q&A specifically says that any interim measures have to be provided to both parties, which means that the complainant, if she or he needs to have a new class assigned, so will the respondent be assigned a new class in order for them to continue their education. The moment any of these policies become burdensome, enforcement is a problem, and complainants feel that as a barrier. The second thing that the September 7th guidance did was it rescinded the 60-day guideline, which is critical when it comes to the ability of the complainant to continue and participate in education. It also rolled back the requirements for preponderance of evidence standard, and it specifically said that campus sexual assault investigations can use clear and convincing standards, which, if I may, is a conflict with even California law as well as federal law. California law Education Code 67386 specifically requires a standard of proof for campus sexual assault investigations to be based on preponderance of evidence. And the new guidelines specifically said campuses are free to choose. Clear and convincing is a rather high bar in cases of violent sexual assault, domestic violence, stalking. It is much harder to prove, which is why California law, even in the context of sexual assault and domestic violence, stalking, those restraining orders can be issued based on preponderance of evidence standard alone. Finally, another problematic piece of the September 7th, 2017 guideline is the fact that campuses are free to choose if they would like to send the investigation out to arbitration. It says something about the fact that both parties have to agree, but nationwide social science research has been following the trauma-informed services and victim-centered services should not provide for arbitration of such cases, and now that's open field.
And the reason that folks argue that arbitration is not the appropriate approach is what, please?
Is because the power and control dynamics in a campus sexual assault or even a domestic violence case, the power and control dynamics shift the power overwhelmingly to the respondent, to the perpetrator, and it forces the survivor to now actually confront the complainant. And one of the protections in the 2011 and 2014 Dear Colleague letters was specifically designed to avoid having the complainant confront the respondent, and all of the investigations could be done by campus authorities via written submissions or individual interviews, and that is no longer required. There will now be an adversarial process if the campus so chooses to follow. The only two other items that I wanted to highlight for the task force is on September 18th, 2017, California passed Senate Bill 169, which is a sex equity bill, which clarified and strengthened provisions for campus sexual assault cases, as well as added sexual violence as part of the description and definition of sexual harassment. And on October 7th, 2017, Attorney General Javier Becerra issued a letter to universities, colleges, local law enforcement, clarifying that Title IX is still the law of the land, adding the preponderance of evidence standard, and clarifying that California law still has preponderance of evidence standard for campus sexual assault cases, as well as reminding campuses that the Education Code has affirmative consent standard as well that's built into investigating campus sexual assault, and that campuses are required to provide affirmative consent related outreach to students and administrators. And the California Department of Justice also offered increased opportunities for training for law enforcement and campus authorities across the state. And then on January 25th, 2018 of this year, Serve Justice, a national organization serving campus sexual assault survivors, National Victims' Rights Law Center in Portland, Oregon, and equal rights advocates in San Francisco, California, together filed a lawsuit in the U.S. District Court, Northern District, against Betsy DeVos, Candace Jackson, and Department of Ed, seeking to vacate the rescission of the Dear Colleague letters.
And full disclosure, my wife is a former board member of Equal Rights Advocates, just to put that on the record. The basis for the challenge legally, does anybody?
Well, if I may, the two salient bases, of course, one is the fact that it raises the standard of proof required, which is constitutionally not sound, and the second is that this is discriminatory based on the fact that the administration has both Candace Jackson as well as Betsy DeVos have on the record stated that their concern is for respondents and not complainants. You know, in their mind, the ability of a respondent to have due process during an investigation and victim-centered and trauma-informed advocacy is a zero-sum game, and therefore, in order to level the playing field, they have removed the requirements for preponderance of evidence. That's my biased reading.
Thank you. Mr. Williams, any comments on the underlying legal rationale? And if not, but I just thought I'd take advantage of having you here.
No, I don't have anything additional to add.
Any other comments from folks who are on the phone on 7C, which is the rescission of the prior administration's guidance? If not, then just from a process standpoint, Ms. Pandy, let me just ask, do I understand that the action in, if I have it right, September of 2017, from a procedural standpoint, is called a rescission letter? Is that the term of art?
That's correct. That's how you'll find it on the Department of Ed's website.
All right. And there's litigation currently underway. And Mr. Williams, is this a piece of litigation to which we are not party? I know we're involved in a lot of things, but...
No, we're not party to this case.
All right. Thank you. Then let's move on to item 7D, pending legislation related to human trafficking. And again, I'll go to Ms. Christian, and I think we have folks from Prime Policy on the line who have also been part of this conversation as well. So Ms. Christian, walk us through it, if you would, please.
Yes, thank you. I wanted to bring to your awareness some federal legislation related to the issue of trafficking and provide you with what I've been able to determine with assistance from Prime Policy Group the status of some of the bills. The first is the Trafficking Victims Protection Act, which is the most consequential federal law on human trafficking. It was originally passed in 2000 and reauthorized 4 times since. The framework is generally referred to as the 3 Ps: protection, prosecution, and prevention. The TVPA also contains the authorizations for the federal funds that are used to fight trafficking and assist victims and survivors. The current set of authorizations expired at the end of September 2017. 3 bills were introduced last year to reauthorize the TVPA. The bill is either whole or in part provided that reauthorization. The House bill, H.R. 2200, was passed by the House. Then there are 2 in the Senate, Senate Bill 1311 and Senate Bill 1312. The Senate passed both bills as well, and at this point we're waiting for the House and the Senate to take action. It's just been a little stalled, I think, probably due to focus on other issues in Congress. Also in the area of human trafficking, I wanted to raise your awareness about 2 additional legislative efforts. Yesterday, the Senate passed the Stop Enabling Sex Traffickers Act, which was passed by the House last month. The bill will now go to the President, and he is expected to sign it. The measure amends current law that provides broad protections that websites have from legal liability for content posted by their users. SESTA, the acronym for the act, creates an exception for sex trafficking and will make it easier to target websites with legal action for enabling such crimes.
And that measure has already passed, as you indicated?
Yes, so it was passed in the House last month. The Senate passed it yesterday, which made my notes dated within minutes. And it will be sent to the President. As I said, media reports indicate that he's expected to sign it.
Thank you. And then as to the human trafficking legislation that's pending, do we have folks from Prime who are still on the call with us who want to offer any additional comments? Sounds like not. Then, Ms. Christian, have we, perhaps I'm being unduly optimistic, but one would think that on a subject like human trafficking, we might be able to find some common ground without regard either to party affiliation or even ideological inclinations. So have we taken any formal position on this legislation as a county under the broad authority that we grant with policies at the outset of the year?
We haven't, just because of focus in other areas.
Let me do this. Let me just ask, and I'm looking to my staff who's here in the chambers today. Let me ask that my office and your office sit down and talk and perhaps bring something formal to the board.
Yes.
To put us on record on these trafficking issues. As I say, you'd like to think that even in the current political climate, this ought to be an area where we could find some common ground. You know, I've said this many times before, and I'm going to keep saying it as the task force convenes. I operate under no illusions that the folks in Washington are waiting, tapping their fingers to hear from Santa Clara County on any given policy issue. That being said, as someone who has been involved in advocacy at the federal level and as someone who was in a legislative environment myself for 12 years, the longer the list of folks who weigh in, the more attention these issues get. That's just a simple fact of legislative politics and the dynamics. So if we feel like we can appropriately add the support of 1.9 million folks in Santa Clara County, we're going to want to do that as necessary and appropriate. Okay, so we'll follow up with you, and I'm looking at my team, and they're nodding their heads as well. Anything else on this issue?
Yes, just one last bill to make you aware of. The Stop, Observe, Ask, and Respond to Health and Wellness Act, which is generally referred to as SOAR, trains healthcare providers to identify potential human trafficking victims, refer victims to service agencies, and provide victims with care tailored to their circumstances. In late February, the House passed its bill on this issue, and now it needs a vote in the Senate to move forward. And of note, Representatives Eshoo and Lofgren were co-sponsors of the House bill.
Great, thank you.
You're welcome.
All right. Anybody on the phone who wants to weigh in on this issue of trafficking? I think we've checked in, but let me check in one more time.
Yeah, just to not relate to those bills, but actually, this is interesting perhaps, that the vehicle they're using to pull the omnibus appropriations bill through the Congress is actually a trafficking bill, the Target Act, that is from the Foreign Affairs and Foreign Relations Committees that makes some adjustments to some programs administered by the State Department in terms of some rewards, some payments for action on these issues. And while it's a fairly narrow scope bill, it's being used as a vehicle to pull forward the appropriations bill, and the underlying bill, the Target Act, passed both the House and Senate by voice vote. So that's being included with all the appropriations language as well.
Thank you. All right, then. Unless there are any other comments or questions on items 7A, B, C, or D, and I'm going to look around the chambers. There are not. Then I'm going to say thank you, and we will follow up. Ms. Pandy, thank you for your participation on these items. And I'm going to look to my staff again and ask that we have a follow-up conversation with you and your office. Okay. That takes us to item number 8, which is to receive a verbal report from the Office of the County Executive relating to the federal fiscal year 2018 budget and appropriations process, and with specific reference to the reauthorization of the Violence Against Women Act and the Victims of Crime Act. Who's going to present on this? Ms. Christian, are we back to you?
We're back to me just to introduce Prime Policy Group. I'd like to ask Prime Policy Group to talk about the federal fiscal year 2018 budget and appropriations process. It's 2 days until the end of the current continuing resolution. So after that information is provided, myself and Ms. Pandy will talk a little bit about the Violence Against Women's Act and the Victims of Crime Act.
All right, and if we could ask the spokesperson from Prime to reintroduce himself or herself, that would be helpful.
Yes, this is Rich Mead from Prime Policy Group, and
Thanks.
as I just mentioned, the Target Act is sort of what we call the vehicle, the bill that is being used to insert all of the funding for the rest of the government for the rest of the fiscal year. And while we were on the call, this bill they filed the omnibus appropriations bill last night, and already the House has approved it 256 to 167. And let me give just sort of a high-level summary of the bill, and then I'm going to pull out a few priorities for the county on it, and then perhaps take some questions. And then, since this information is, like I said, only was filed last night a little after 8 p.m. Eastern Time, we're still running through and, and reading all the details of it, but nevertheless, let me continue with my report. So, as I mentioned, this bill, the Target Act, is carrying the 12 appropriations bills to fund all of the government for the rest of the fiscal year. It's also carrying 6 extensions of some other laws, like the Federal Aviation Administration Authorization Act and a few others. There's 6 extensions of other authorization bills. And there are 16 non-appropriations, what we call policy riders, unrelated bills are attached to it. And when I say the number 16, that may sound like a lot, but really, truly, there were probably hundreds upon hundreds of ideas and bills put forward for being contained in this bill, and they only pulled out 16, so it's actually a fairly narrow number. And in terms of some of the priorities, the Violence Against Women Act funding was, the final number was $492 million, which was sort of a compromise between a slightly higher level in the House passed bill and a slightly lower level in the Senate reported bill. The Victims of Crime Act, the new cap on the Crime Victim Fund is set at $4.4 billion. The previous cap was at about $3 billion, so it was a significant increase in that cap. In terms of funding at the Centers for Disease Control, CDC, injury prevention and control received $648,559,000, and I want to call out under that number, there's $49.430 million for rape prevention. One other item of note at the Centers for Disease Control, in the appropriations bill, the Appropriations Committee noted that Secretary Azar has stated that the Centers for Disease Control can do research on gun violence. There continues, though, a prohibition about the Centers for Disease Control lobbying on gun-related legislation, but nevertheless they can conduct research on gun violence, which is something they've not done for quite a number of years. So there seems to be a little bit of a shift in policy at the Centers for Disease Control. So let me pause there for any questions or comments from the board.
Thank you. Let me ask if you could go back to, and I'm asking candidly because it's a matter of particular interest to me and my office, to the shift in policy, if any, or at least a potential shift in policy on gun violence research. Could you go back and just restate that again and maybe provide just a little bit more detail about what's in the offing?
Yeah, so I think it was 1996, there was an appropriations bill that contained the so-called Dickey Amendment for Congressman Jay Dickey from Arkansas that had a prohibition, a broad prohibition on the Centers for Disease Control in terms of gun violence. And the new HHS Secretary Azar, in a hearing before the Appropriations Committee, said, I don't interpret that rider as prohibiting the base research. It prohibits us from doing advocacy based upon the research, but just doing the research itself, we feel as though we can do that in our current law. So the significance here is that the House Appropriations Committee specifically states in the appropriations bill that interpretation of the law by the new HHS Secretary that the Centers for Disease Control can now do research on gun violence. So that's the big shift.
Yeah, I'm, maybe my perspective is skewed. I can understand how from the standpoint of the general public, that might not seem like a particularly significant development. Sounds a little wonky, if you'll forgive me for putting it that way. But, based on my understanding, I mean, if we're at a place where we can, after 20 years, finally move forward at the federal level with some meaningful research in the area of gun violence, that's not a small thing. Do people in Washington think that's noteworthy? I guess let me ask the question that way.
No, I think this is a pretty significant shift, and like you said, yes, it's wonky and it's very sort of inside baseball, if you will, but this is a really significant shift, and I think one of the things that we're finding out is that Secretary Azar is probably not as conservative as his predecessor, Secretary Price, and I think he's more willing to do things like conduct this research. He's more willing, and this is off topic a bit, but he, for example, is willing to use the Centers for Medicare and Medicaid Innovation that's created by the Affordable Care Act, whereas Secretary Price didn't want to engage with that office at all. Secretary Azar is more willing to do that, so I think you're going to see a much more open Secretary of Health and Human Services on a few issues at least than his predecessor.
All right, thank you. All right, then let me say thank you and bring it back to our team, who I think had some comments they wanted to offer at this point here in the room.
Thank you. Actually, Mr. Mead covered the budget items on the the Violence Against Women's Act. I'm trying not to defer to the acronyms right off the bat. And the Victims of Crime Act. I will point out that the funding level that he mentioned is higher than what the Violence Against Women's Act was funded at last year, so that's good news. So with that, I'm actually going to ask Ms. Pandy to talk a little bit about the reauthorization of VAWA and some of the policy concerns that are starting to form in that arena.
Thank you.
Thank you, Ms. Christian. So as I mentioned earlier, one of the big worries nationwide, and I will name the groups that are working on the VAWA reauthorization and getting education and outreach done nationwide. Jewish Women's International, National Women's Law Center, as well as the American Bar Association Commission on Domestic and Sexual Violence. I happen to serve, this is my last year as one of the 17 commissioners nationwide on the ABA Commission, but I am involved in the reauthorization discussions. Besides the piece that I mentioned earlier, the big worry right now is that the immigration environment is going to spill into the reauthorization piece, where U visas and T visas and the quota for U and T visas are contained in the Violence Against Women Act. And so there is a fear that the quota will be brought down. And along with that, the other piece that advocates nationwide are worried about is the addition of fraud and misrepresentation and language relating to fraud and misrepresentation in the context of the immigration relief for victims of violent crime who are undocumented persons. The other piece that's worrisome is the riders that might be put on a provision in 2013 that allowed for Native American tribal courts to have jurisdiction over non-Native perpetrators of domestic violence if the survivor of domestic violence is Native. And so the worry is that instead of expanding those provisions, they'll roll it back and allow for both the tribal courts as well as other courts to hear that case, and that will cause the classic, forum shopping, if you will, that does add to barriers for survivors. Right now, the fear also is the LGBTIQ persons and their protections that are specifically enumerated in VAWA will be tagged along with the moral and religious exemptions, and they'll add the moral and religious exemptions to the provisions that prohibit discrimination based on gender identity and sexual orientation.
And Ms. Pandy, excuse the interruption, I just want to make sure I'm tracking here. These are debates that are playing out as the reauthorization of the Violence Against Women Act and the Victims of Crime Act are being debated and considered. Am I tracking that right?
Right, it has not, the VAWA reauthorization has not yet been introduced, but the field is watching and outreaching to gather all of the pieces that the field is worried about, and also to decide what advocacy should be done on how to expand VAWA this time around. And so the consensus in the field is we won't talk about expansions on the immigration piece at all, but we'll keep an eye out on what is added, which might roll back the 2013 developments. And the specific context of that is now Attorney General Sessions was Senator Sessions in 2013 when VAWA was reauthorized, and that's when the 3 big protections came in relating to Native American tribal courts, LGBTIQ persons, as well as the increase in the quota for immigration for visas for victims of violent crime who are undocumented.
Thank you. And before you go on, if you could just, so the timeline we think on the Violence Against Women Act is what again?
So it should be introduced sometime in the summer, and then there's a 2-year, I'm looking at Ms. Christian for the specifics.
I would need to go back and reconfirm
Sure.
the exact date, but it's my understanding that the Violence Against Women's Act expires this year. So I think that the organizations that Ms. Pandy discussed are starting to kind of queue up what they think are things on the horizon that they need to be watchful of as activity gets started, but an actual bill hasn't been introduced.
Thanks. I'll ask my office to follow up with you just on the timeline issue, which is I'm trying to get a sense for what the timeline is, because that will inform, obviously, any action we might want to take here at the county. And Ms. Bandy, thank you for letting me sort of get myself squared away. I did not mean to take you off track.
No, I'm done. That was all I had, Supervisor.
All right. Well, then I'll say, anyone on the phone who wants to share any information on this issue as well? All right. Then if not, I think the one question I have at this point is about the timeline, and I'll ask my office to be in touch with your 2 offices to make sure we understand that. And as I say, it's not an abstract question. It's really a question that would allow us to think more about what we might do and when we would need to do it if we want to weigh in on some of these issues. All right, then if there's nothing else, and I want to make sure that that will bring us to the end of the panel today. Anything else before we, because we've taken care of item number 9, and item number 10 is the adjournment. So before we bring down the imaginary gavel, let me turn and County Council, County Executive's Office, nothing additional. Ms. Pandy, Ms. Christian, nothing else. All right. Then without objection, and let me say first thank you again to everybody who participated and helped. Then without objection, we stand adjourned to our next regular meeting. Thank you so much.